Good afternoon and welcome to the Empowered Together Navigating Legal Changes in Response to COVID-19 webinar presented by the LevittQuinn Family Law Center and the Reape-Rickett Law Firm. My name is Sarah and Anastasia and I will be assisting in today's webinar. Joining us to discuss our topic today, the impact of COVID-19 on child custody, visitation, and support, are LevittQuinn attorney Nalleli Sandoval and Reape-Rickett attorney Laurence Goldman. Mr. Goldman has been practicing family law for over 40 years and has been a certified family law specialist since 1990. In addition to his extensive experience, Mr. Goldman is a member of the board for the Public Council, is actively involved in the business community and other professional organizations. Ms. Sandoval is the staff attorney and community engagement coordinator at LevittQuinn. When not assisting her clients, Ms. Sandoval works to connect legal information and access to underserved communities. This afternoon, Mr. Goldman and Ms. Sandoval will discuss how court closures and limitations are affecting child custody, visitation, and support issues, as well as what to expect once the courts are able to reopen. Our presentation will focus on Los Angeles Superior County, even though we will address other counties such as Ventura. Additionally, they will provide information and resources for co-parenting tools, including explaining the guidelines for visitation exchanges and existing orders. Finally, Ms. Sandoval and Mr. Goldman will address questions submitted by our audience to help you navigate the current situation. We encourage you to submit your questions during the presentation and we'll address as many questions as possible, time permitting. Please note that we are unable to address any case-specific questions or information, so please do not submit any personal information. Also, the information presented in these slides, along with the links, will be sent out to you after the webinar for your review and reference. To get us started, Ms. Sandoval will review the status of the family law courts.
Good afternoon, everyone. Before getting into our topic for today, I wanted to give you a short rundown of what we talked about in our last webinar and some updates since then. I want to stress that any information that we give you is accurate as of today, but as the situation continues to change, so may the information that we are giving you. In Los Angeles, the courts are planning to reopen on June 22nd. Until then, the court will continue to only hear essential matters like ex partes, restraining orders, international child kidnappings under the Hague Convention, and 3130 matters with district attorneys involved. The court continues to process any non-emergency filings like judgments and continues to accept any new filings like petitions or requests for order. To file something, you can do so through mail, fax, or a physical drop box located at all of the courts servicing family law in Los Angeles County. Lastly, at this time, the Los Angeles courts have a few options for appearing. It can still be done in person or remotely by court call, or WebEx if you are in Department 18 or 22 of the Stanley Moss Courthouse. Again, for now, these options are only for people who have essential matter hearings going on. In Ventura County, the court is planning to reopen on June 9th. Until then, the court is only hearing ex partes and restraining order matters. It is also only accepting filings for these types of matters and no other kind, meaning no new filings like requests for orders or petitions are being accepted. If you file one of these things, it will be rejected. But if you're filing an ex parte or a restraining order, it can be filed via mail or at a physical drop box located at the Hall of Justice. Appearances in Ventura for ex partes and restraining orders can be done in person or remotely through a conference call. And since we're talking about the courts, I do want to remind everyone that at least in Los Angeles County, the court is asking everybody to wear a mask and will continue to do so when it reopens. If you don't have a mask, they will have some available for you. Also, social distancing will be enforced. So for those of you who have been to court before, it will look different. There will be spacing markers, among other things.
Good afternoon, and thank you for joining our presentation. We are in a brave new world. How is visitation custody to be conducted during this period of time? Some counties have provided insight to this. As an example, in Ventura and Santa Barbara, they have stated that COVID-19 is not a reason to deny parenting time or to refuse to return the children after a visitation. We do not have guidelines in Los Angeles County, and many other counties have not done so either. But as a family law attorney, I know that if there's a court order, then the order is to be followed. The parties are supposed to have frequent and continuing contact with their children. I want to mention self-help. If one parent takes it upon himself or herself to make unilateral decisions, as you will hear later on, those decisions will not be looked upon with favor with the court. Keep the visitation going. It is important more than ever that each parent talks with each other and resolve issues. The parties need to be flexible, use common sense, and this is for the best interest of the children. Nalleli, I turn it back to you.
Thank you, Larry. We want to stress that COVID-19 by itself is not a reason to stop visitation or to stop following your orders. If you read or review some of the guidelines, you'll find that most counties encourage parents to follow their regular parenting plan as closely as possible. There will be a link in the slides if you wish to review any of these guidelines. And while COVID-19 has made things more difficult, it's important to note that communication with the other side continues to be extremely important during this time. With the court being closed to most matters, it's up to you guys to talk and try to resolve issues to the best of your ability. If you're having an issue, please talk to the other side about it before automatically running to the court to file something. Now, if for some reason one party did stop visitation, if and when you guys return to court, the person who denied the visitation is going to have to explain that to the court. A few of the things that the court is going to consider is whether one person used COVID-19 and the quarantine to their advantage. If this is the case, the court is not likely to rule favorably for that person. There are going to be consequences for parents using this pandemic to their advantage. Also, the court needs to determine if there were sufficient facts or good enough facts to deny the visits. Just the fact that COVID-19 exists, just the fact that we're in a quarantine, those facts by themselves are not good enough. Ventura County has actually specifically stated in its guidelines that unreasonable denial of the other parent's custodial time due to COVID-19 shall be considered in any subsequent modification of custody and visitation. It continues to be public policy in California that frequent and continuous contact with both parents is important, and even during this time.
Let's now address some visitation issues. Even though our children are being homeschooled, we should consider the visitation schedule as if school is in session. This is important for the children. It will provide them stability and help them get through this time, which is hard on everyone. With respect to monitored visitation or supervised visitation, most counties have suspended those types of visitation. But that doesn't mean that the person who's having visitation being monitored shouldn't have contact with the child or children. Use the telephone, Skype, FaceTime, and Zoom so that that parent has the frequent and continuing contact with the children. I would like to mention that on June 1st, there are changes in Ventura County which will allow supervised visitation to commence. If you do have supervised visitation, I suggest you find out if your monitor is still going to be able to do that. If not, now is the time to start looking for a new monitor to conduct the supervised visitation. Travel. This is not an easy issue if parties are living in different, especially if parties are living in different states. Is there an acceptable common carrier that is available? If not, this is again time for the parents to talk to each other and discuss how the visitation can be conducted, whether by Zoom, FaceTime, and whether the visitation will be allowed to take place at a later date. Again, the lines of communications must be opened up. because issues like this are going to come about. And that's part of the communications. It is now more than ever to talk about these things. And remember one thing, it is not what is best for the parents, but what is in the best interest of the children. One last item, talking about exchanges. In the city of Los Angeles, most police stations are locked down. They will not allow the public into the lobby. Therefore, if you have an order where exchange of the children is to take place at the police station, it could take place outside the lobby, in the parking lot of the police station, or maybe you want to consider some other public place like McDonald's or Chick-fil-A. You may also want to consider curbside exchanges. Again, this is something that you need to talk with the other parent and resolve these issues without having to go back to court.
Now, we understand that during this time, there have been a lot of layoffs. So we want to talk a little bit about child support modifications. Filing a request for order, or an RFO, to modify child support is considered a non-emergency filing. If you remember from one of the first slides, that Los Angeles is accepting non-emergency filings, while Ventura is not. So the way you go about a modification will differ between counties. Now, it is important to file your modification as soon as possible for retroactivity purposes. Retroactivity is important because no matter how far out in the future you have a hearing, the court can make the order retroactive or go back to the date that you filed or served the other side. In Los Angeles, the order could be retroactive to the date that you filed, and in Ventura, it could be retroactive to the day that you served the other party in person or by mail, since you can't file in Ventura. Some situations that would support a filing for a modification include having reduced income or reduced hours at work, being laid off or fired, or for those of you who are self-employed with businesses, it could be the loss of your business during this time. Something else that we want you to keep in mind when deciding whether to file a modification is how likely you are to remain unemployed or furloughed or work at a reduced time or rate. If you're going to go back to work in a month or two, you have to consider how worthwhile it is to file a modification if the other side is just going to have to file another one to get the old order back in place shortly thereafter. What's most important is a conversation with the other parent and potentially an agreement to temporarily lessen the amount of child support could be an option to consider. The Child Support Services Department website has a calculator that is similar to what the court uses if you need some help with calculating what should be the appropriate support during this time. If you're interested, the materials will have a link to that calculator. Below are some of the key differences between filing modifications in each county. Since Los Angeles courts are accepting and processing non-emergency filings, the Supreme Court Emergency Rule number 13 does not apply in Los Angeles. For those of you who don't know about Emergency Rule number 13, it helps people who need to file a motion for a modification in counties that are not accepting non-emergency filings, like Ventura. It allows the order to be retroactive to the date that you personally serve or mail the motion to the other side. So while you can't file in Ventura, you can still complete the paperwork and then have it served or mailed on the other side so that whenever you do get a hearing date, it can be retroactive or go back to the date that you served them that paperwork, even if it isn't filed.
Let's now talk about some resources that are available to parents. In Los Angeles County, we have the Online Dispute Resolution. This is an online tool for parents to resolve and negotiate a parenting plan. It is initiated by one of the parties opening up the program and submitting what their proposal is. The other party will then respond to it. Negotiations will take place. And if a plan is agreed upon, then the program will prepare the written parenting agreement, which will be filed with the court. And at this period of time, there is no charge for this online tool. It's very important. There are two other software programs that we want to bring to your attention. That is Our Family Wizard and Talking Parents. These are software programs that allow parties to talk to each other by communications. And what is important about these programs is that these communications will be saved and can be printed out at a later time. Now, Nalleli talked about matters being resolved and maybe go back to the old order without having to file a written request for order. Well, this is a way that you can do it in writing and it will be there. With respect to Our Family Wizard, some of the cost will be waived if a party has a fee waiver. I cannot stress to you that use all the resources that are available to you and talk with the other parent. The more that can be resolved out of court, the better it is. And I just want to mention one other item about court. If your matter has to go to court, that person in the black robe will only have a few minutes to make a determination. They have never seen you or your children or the other side before. They don't know what's going on, and they will have to make a decision that is as to what is being presented at that time. The more that you can resolve yourself and be flexible, the better it is that you don't have to take it to a court.
As the court begins to make plans to reopen, we want to update you on some of the functions and dates associated with the court. Now, the information that we're giving you is only for Los Angeles County, as Ventura hasn't released any information. I believe the bulk of what we're presenting is for Los Angeles County, but we are giving you information on some of the other counties like Ventura. In Los Angeles, the family court services will start doing mediations again beginning on June 15th. Now, when it comes to parenting plan assessments or child interviews, the judges will be the ones making the decision. Will be making the decision as to whether the parenting plan assessment or child interview should go forward. If the judge has enough information to make a decision on their own, then he or she will take the parenting plan assessment or child interview off calendar and make the appropriate determinations. If the judge does not have enough information, then the parenting plan assessment or child interview will continue, but understand that it's not likely to be scheduled before September 21st. If a judge is in between, then you may have to have a hearing so that the judge can decide whether the parenting plan assessment or child interview is necessary. It'll look sort of like a review hearing. Now, moving on to hearings. While we will be discussing priority in the next slide, there are other things that I want to talk to you about regarding hearings. It's important to note that when you do have a hearing, regardless of how far out in the future it is, your time in front of the judge and in the courtroom will be limited. So you need to be prepared, and you need to be able to present your information in a clear and succinct manner. There's no point in repeating everything that you wrote down in your filed documents or telling them the entire story from beginning until end. You simply just won't have time for that. So be thoughtful in what you decide to present to the court. But of course, don't be afraid to ask questions, write things down, and be prepared. For meet and confers, it's important to abide by Rule 5.98 of the California Rules of Court. If you don't do this before your hearing, you risk having your hearing continued out to another day. I assume this is something that everybody wants to avoid because of how long it currently takes to get a hearing. The requirement for a meet and confer applies to everyone. Doesn't matter whether you're representing yourself or whether you have an attorney. For those of you who don't know what a meet and confer is, it is what it sounds like. You have to meet with the other side before your hearing. Now, meeting with the other side doesn't necessarily have to be a sit down, doesn't have to be in person. You can use email, or you can even use one of the platforms of communication that Larry went through in the previous slide. Now, don't wait until the morning of your hearing to be able to expect to talk to the other side out in the hall. That won't be good enough anymore. Once you're meeting with them, you need to talk to them and resolve any issues possible before going to court. If you can't agree on everything, that's okay. Partial agreements are okay. That way, when you're in front of the judge the court has less things that it has to decide for you guys. The last few important points are that the child care center will be closed, so don't bring your children to court. And lastly, the self-help center will be opening on June 15th, but it will work differently. You will not be making a line outside of the self-help center like before. Instead, there will be appointments, and you will need to show proof of that appointment before being allowed into the courthouse or into that self-help center. I've given you guys a lot of dates here, but of course, all of it is subject to change if the safer at home order ends up being extended.
When the courts closed in mid-March, there were approximately 32,000 family law matters that were set to be heard. Almost 3 months have passed since that period of time. It is our understanding that approximately 100 family law matters are being filed on a daily basis. There are going to be a lot of matters to be heard. And what Los Angeles County is going to do is to have the individual family law judges prioritize their calendars. And you got to keep in mind that the number of family law judicial officers is a limiting effect as to how many matters can be heard on a daily basis. The first priority for the judicial officers will be all restraining orders, post-arraignment contempts, requests for custody orders involving the district attorney, and international kidnapping Hague Convention matters. Category 2, priority 2, will be initial request for orders for custody, support, attorney's fees, urgent requests for orders and custody modifications that may have been set on an ex parte application, and default trials. The third category for priority of cases is request for orders for modifications of custody and support orders which are already in effect, current orders. Finally, category 4 will be all other matters. It is our understanding that it may be on Labor Day when the courts are able to get through categories 1 and 2. If there's anything that we have to keep in mind with getting matters heard, whether you're self-represented or an attorney, everyone will have to exercise patience. There are only so many judicial officers, there's so many cases, and we have to have patience while we wait for our cases to be heard.
Thank you, Mr. Goldman. That wraps up the presentation portion for today's webinar. Mr. Goldman and Ms. Sandoval will now address questions submitted by our audience, starting with some of the questions submitted at the registration process. And please feel free to submit your questions via the Q&A. We will get to those as soon as possible and do our best to answer as many as possible with time permitting. And again, please don't submit any case-specific questions or personal details, as we aren't able to discuss those concerns in a public setting. So to get us started with our first question, if my income has been reduced as a result of being laid off, can I request a modification of support, and will that affect orders for health insurance coverage?
This is an excellent question, and I'm going to deal with it in 2 parts. The first part is, if my income has been reduced as a result of being laid off, can I request a modification of support? The answer is yes. You can file your modification depending upon which county you're in Los Angeles County, by filing a modification, or if you're in Ventura, using emergency rule number 13. But I would like to put as an aside, these are one of the things that Nellie had talked about earlier. Maybe you can resolve these issues for the period of time that the person is laid off. If they're going to go back to work, then maybe you can resolve the issues for the short period of time so that you don't have to file numerous requests for orders to first lower the support and then go back to what the current order was. The second part of the question is more difficult. Will that affect orders for health insurance coverage? We don't have enough information, but if the support order that is in effect provides that the employed spouse is to maintain health insurance, especially for children, then that should be attempted to be maintained. But the question may be, if the person was laid off, did they lose their health insurance coverage? This is something that may have to be decided later on by the court, but if you can reserve or comment on it with the other side pending the hearing as to whether or not to go to California Obamacare type health insurance pending the time you're laid off, there are many issues that you could discuss and work on for this part of the question.
All right, thank you, Mr. Goldman. We're going to pivot to our second question. What can I do if I have orders for supervised visitation, but no one is available to be the monitor?
If you have orders for supervised visitation, I would try communicating with the other side and seeing what other alternatives there are if a supervisor is not available. Mr. Goldman referred to these with respect to FaceTime, video calls, things of that nature could help during this time. And second, be aware and open to counties opening up. Ventura County is planning on opening up, and so there will be supervisors available. So keep an eye out on that and see if there are appropriate monitors starting to become available in your county.
Thank you, Ms. Sandoval. I do see that we have a few audience questions, and we will try and answer as many as possible. And Mr. Goldman, if you could see the initial question regarding travel and the time frame, would you be able to address this question?
Yes.
Wonderful, thank you.
The question is, I have a 14-day vacation notice to travel on a 50-50 custody order. Can she, I guess they're talking about the other party, stop me from traveling on July 2nd because of COVID-19 when I gave her the proper notice and followed the order? Thank you. This refers to part of what we had talked about before. Is there an acceptable common carrier available to do the transportation? I don't know where the parties are located. Is one party in California and one party in Texas? This is an important question in that it questions the parties getting together on either Zoom or one of the software programs we talked about and try to discuss what is done. As an example, is there not an acceptable common carrier that is available? Maybe the visitation is made up at a later date. Be flexible. Work so that that out-of-state parent can continue to have his or her frequent and continuing contact with the child. Try to work it out yourself.
All right, and we have another question. I believe the next two kind of go together, so I'll answer them in one. The question is, how can the juvenile court rule that visitation is unsafe, yet family law is forcing visitation abate unsafe? Juvenile court found in-person visitation poses imminent health and safety risk on March 20. Why not so for family court? Well, I can't speak to the juvenile court. I can speak to the family court. And we have mentioned this time and time again that frequent and continuous contact with both parties is what is best for the child. Therefore, that is why the family court continues to support the idea of visitation during this time. I don't know if, Larry, you have anything to add to that, but.
Yes, I do. These questions seem to imply that there is jurisdiction with the juvenile court at this time, that there is no jurisdiction with the family law court. If that is true, then the juvenile court overrules what takes place with what we tell you with the family law courtroom. They have to give up their jurisdiction first before the family law rules will come into effect.
Thank you, Mr. Goldman, and thank you, Ms. Sandoval, so much for answering those questions and for the presentation today. It is now that we've reached the end of that portion, And we'd like to submit a poll for everyone who's attended. We greatly appreciate if you're able to participate. Give us some feedback as to what was helpful. And again, thank you so much for joining us today to review the impact of COVID-19 on child custody, visitation, and support, as well as those who were able to participate in our Q&A session. We hope you found this information as empowering and will help you navigate the family law issues during this health crisis. In the event you have case-specific questions or concerns, you can contact LevittQuinn Family Law Center or the Reape-Rickett Law Firm via the information provided here.